United States immigration waivers. You may need one if you're applying for a US visa, immigrant or non-immigrant, a green card, or sometimes even if you are already a green card holder. Immigration waivers in the United States immigration law, special tools, or I would describe them as special forgiveness that the United States government can give to a person if they're found in violation of some immigration-related law or regulation. Immigration laws and regulations in the United States are very complex. The law is constantly changing and it's hard sometimes to keep track of what's going on. Also, there are so many different details that one has to keep in mind when he or she is filing for that visa or green card. And sometimes what happens is that the person makes one silly mistake and they're found inadmissible. However, most commonly, a person would need a waiver if there is some criminal past, criminal conviction or arrest, if there was finding of misrepresentation or fraud in one's record, or at times when none of the above, but there was a mistake done, sometimes even by the government, through no fault of a person, but they found to be inadmissible. Today I'm going to talk about what types of waivers are out there, how you can file for one, what you need to do so procedurally, and I'm going to focus in the end on what, in my opinion, after practicing law in the United States for 15 years, helps to win an immigration waiver. Thank you very much for watching. My name is Alena Shautsova. I'm an immigration attorney from New York. I've been practicing law in the United States for almost 15 years, focusing my practice exclusively on immigration issues. However, I do have expertise in criminal law as well, and international law and family law. So when you come to our office, we help you to understand how all these different areas of law are interacting with each other and how they may influence your immigration process, which is very, very important. If you have not subscribed to my channel, please do so, and let's start. If I had to, I would divide all waivers to immigrant waivers and non-immigrant waivers. Immigrant waivers are used in connection with green card application or an immigrant visa, which is a permanent resident visa, and non-immigrant waivers are used in connection with non-immigrant visas. For example, it's very interesting that somebody who can be found guilty of a crime, let's say something related to controlled substance, will not be able to come to the United States on an immigrant visa because there is no waiver for that usually, except for one very tiny exception, but will be able to come to the United States sometimes on a non-immigrant visa. Why? Because a non-immigrant waiver is going to waive almost everything. There is a special waiver for that, and immigrant waivers are very, very restrictive. For immigrant waivers, usually you would need to have something very important. Focus your attention: qualified relative. Usually it will be a permanent resident or a green card holder, spouse or parent, usually, okay, very important. But for a non-immigrant waiver of inadmissibility, you don't have to have a qualified relative. You don't have to show hardship to them. You can just show, among other things, rehabilitation, that you're not danger to public and national security. Non-immigrant waivers are easier to receive. For example, 212D3 waiver, you may have heard of it if you are watching this video and doing your research, is a waiver that is commonly used for somebody who would like to come to the United States on a non-immigrant visa, such as a work visa, for example, L1, F1 student visa, but they have something in their past, perhaps a criminal conviction of some sort, and they are technically inadmissible. So what are you going to do? You're going to file for that 212D3 waiver, and it's going to work, hopefully, if you win your waiver and your waiver is approved. But for the same person, if the person is marrying a US citizen, for example, and is found inadmissible, they would have to file for a different waiver if the law permits. Let's say there is a criminal conviction of something related to shoplifting of some sort, right? And technically makes a person inadmissible. It doesn't fall into any exceptions, like a petty offense exception. The person will need a waiver. It's going to be a different waiver with a different procedure to file for, even though both people or the same person files for a visa, the procedure and qualification for a waiver will be different. So the first thing to determine when you're dealing with waivers is what kind of waiver can you use if a waiver is available, sometimes when you are in a consulate, the consular officer who is denying your visa is going to give you a hint saying a waiver is available, or they're going to say the waiver may be available, but there is no qualifying relative. Or sometimes they erroneously going to say that there is no waiver when there is one. So it's always a good idea to consult with an attorney. I'm going to tell you something, that if you had any concern in the past about your application, if you had any criminal encounter, always consult with a lawyer before filing for immigration benefits. Another thing about the waivers is not only qualifying relatives that you need. Most likely you will have to show some sort of good moral character. What is it that you are doing with yourself? If you're a good person, if you're volunteering, how is it that you can contribute to the society? I wouldn't say that those are obligatory qualifications that you must show, but they surely help. Now, let's say you discovered that you do need a waiver, you did your research, you found out that these are the qualifications, 1, 2, 3, and what do you actually need to do to file for one? Well, I'm going to tell you the procedure for filing for the waiver will depend on whether you're filing for, let's say, I-601A waiver. For that waiver, you would have to file before you are submitting application for your immigrant visa. But after you pay a fee for the immigrant visa, if you are filing for immigrant visa or non-immigrant visa at the consulate, most likely you first have to have your interview. That's usually the case. Get denied and then file for the waiver, or you're going to submit your waiver at the time of the interview sometimes, if we're talking about non-immigrant visa waiver. While you're in the United States, there are instances when you can file for the waiver only if you are in removal proceedings. For example, you were accused of marriage fraud. Marriage fraud, as you may be aware, if you're doing your research again, does not give you an opportunity to file for any waiver usually. If you're charged with 204C admissibility based on marriage fraud in the United States, you cannot file for the waiver unless you are in removal proceedings. There is a special waiver if you're in removal proceedings. Under certain conditions, you may be a lucky one, if you call it lucky, removal proceedings meaning deportation, and you may be able to file for that special waiver. So you see how complex that is. Sometimes you can file for the waiver before you go for the visa, sometimes only after, sometimes only if you are already in removal proceedings. Most likely you're going to use one of the forms when you're submitting for the waiver, for example, form I-601. Sometimes you have to submit form I-212. It depends on what is it that you are asking for. What is your ground of inadmissibility? Sometimes there is no form to submit, and you and your lawyer need to know when to use which form and when there is no form. For example, 212D3 waiver is the most confusing waiver. There is no form for it to file, but there are certain expectations. And the way you learn about those expectations, usually from experience, from practice, reading cases and examples, to understand what is it that the consular office is going to look for when they're trying to determine whether or not they will finally allow you to come to the United States. Don't forget, very important point, for most waivers there is a fee to pay. There is a fee to pay, but not for all of them. Some waivers come for free to you. Of course, you may have to pay for lawyers' fees, and waivers are usually very expensive. Why? Because they require a lot of labor to be put in. A good waiver preparation probably going to take 20 to 40 hours of attorney's time. So go by that and you will see that it's going to be a good amount of money that you will have to spend, but hopefully the result will be outstanding and you will resolve your problem once and for all. Because unless we're talking about non-immigrant waivers that are given usually for the most 5 years, an immigrant waiver is going to waive that ground of inadmissibility once and for all. For example, you're sponsoring your parent for a green card. Your parent was in the United States previously, has been visiting the United States with no problems, and now your parent went for that immigrant visa. But immigrant visa was denied. Why? Because consular officer reviewed your parent's application for non-immigrant visa and found out that your parent misrepresented employment experience in the visa non-immigrant visa, tourist visa application. Now your parent will never come to the United States unless there is a waiver available. For example, you were able to sponsor your other parent, and your other parent is already a green card holder, and you can establish, or rather your parent will be able to establish extreme hardship to their spouse who is now permanent resident if the parent who was found inadmissible cannot join them in the United States. So see how little mistake may cause this huge forever inadmissibility unless a waiver is granted. The good news is that if the waiver is granted, we're talking right now about misrepresentation or fraud waiver, the parent will have no problems coming to the United States and later filing for their citizenship. And finally, the most important part of this video for you, I think. So what works? What helps to win a waiver? I'm going to share with you 3 things which I find extremely helpful. Number 1, and it's probably the hardest thing, is the theme of your waiver. What is that you're trying to convince the officer of? Good trial lawyers are going to tell you that if you are going to try a case, you better have that theme. You better have some sort of a story you would like to convey to the juries that they will be able to relate to and understand why your client is not guilty. The same thing is going on here. Waiver implies that you admit that you are guilty of certain violation, but then you have to present a compelling story as to why you should be forgiven. Extremely important. Number 2, strong paper evidence. You have to produce documents that a consular officer or USCIS officer is expecting to see, because it's customary to produce those documents in support of your waiver, such as medical records, such as financial records, your story written up, typed up, not just a letter that some people say call it hardship letter. I call it a life story. They need to understand what happened to you and how it's affecting everybody around you. Very, very important. Psychological evaluation, guys, extremely important to demonstrate emotional hardships to your qualifying relative if you are filing for the waiver that requires that extreme hardship connection. Those are very, very important things. And finally, what I find the most helpful would be a memorandum, legal explanation that an attorney creates to convince the adjudicator, the person who is deciding your waiver, as to why that waiver should be granted. We use your record, meaning that evidence organized. We use arguments that sometimes we have to come up with those arguments. They cannot come from you. It's very, very important. A lawyer has to advocate on your behalf. And I find those memos are extremely helpful. If you are in immigration court filing for something, I'm going to tell you that those memos are about 80% of your success. Well, now you know almost everything about immigration waivers in the United States. I hope you enjoyed this video. If you did, like and share it. And we're going to see each other soon with more exciting, never boring immigration topics if you subscribe to my channel.